Good afternoon. Thank you all very much for coming. It's my distinct pleasure to moderate this panel this afternoon. And to facilitate my doing so, I'm hoping that you might engage in the following thought experiment. Imagine that you're reading a respectable newspaper or periodical. Stipulate that somehow, some way, you find yourself in the personal ads. Since you just happen to be there, your eyes, but not you, peruse these ads. They fixate on one in particular that read something like the following. Black acting and black looking heterosexual man seeks white acting and black looking heterosexual woman. You're not quite sure what to make of this ad. You reread it. Black acting and black looking heterosexual man seeks white acting and black looking heterosexual woman. Perplexed, you ask yourself the Marvin Gaye question, which is to say, what's going on? You query, again channeling Marvin Gaye, what kind of sexual healing is that? Somehow, some way, you find yourself out of the personal ads and onto a space you find more ontologically manageable, which is to say, front page news. There you begin to read an article about whether Barack Obama is insufficiently black, about whether he acts white. In that very article, a similar question is being raised about Hillary Clinton, that is to say, whether she acts too much like a man and not enough like a woman. I've never seen all this identity acting language before, you think. Never. Ever, ever. You share this observation with a friend who has this to say. Well, that's because you've never found yourself, some way, somehow, in the marketplace of gay desire, which is to say, gay personal ads. In that domain, the language of identity acting is ubiquitous. And indeed, upon looking at these ads, you discover that personal ads that read, quote, straight acting GML seeks the same, and, quote, in search of a BLK thug, where thug is a stand-in for acting out a particular masculinity, are not at all uncommon. You leave the personal ads wondering what your next identity act will be. Now, significantly, I start with this conversation about personal ads because the presence of these ads and their acting identity signification speak not only to access to love or sex, they speak to our access to opportunity more broadly. The ads I've described suggest that the desirability and undesirability, normativity and non-normativity of our identities turns not just on the categories we occupy in a status sense, that is, whether a person, for example, is quote-unquote Asian and or gay, but how we act out these identities or are perceived to act out these identities might matter as well. That is, whether the person is Asian and gay is perceived to act white or straight. The panel today, entitled Marketplaces and Desires, the Economics of Racial and Homoerotic Representation, wants us to think about the relationship between employment discrimination on the one hand and aesthetics, desire, and identity on the other, particularly as the three come together in the form of advertisements, grooming policies, and other forms of corporate branding. To make the conversation concrete, much of our discussion will focus on Abercrombie and Fitch as a company, a public relations campaign, a purveyor of cultural and identity iconography, and an employer. We have a very distinguished group of panelists who will help us think about precisely these questions. Our point of departure is an examination of Abercrombie and Fitch's adverts, whether we might consider them a form of hate speech, and whether the adverts suggest that sexual equality can be accomplished without racial diversity. Professor David Eng will help us pick up precisely these questions. Professor Eng is a professor of English and comparative literature and a core faculty member of Asian American Studies at the University of Pennsylvania. He specializes in Asian American literature, Asian American studies, Asian diaspora, and critical race theory. He is the author of Racial Castration, Managing Masculinity in Asia America, and the forthcoming The Feeling of Kinship, Queer Liberation and the Racialization of Intimacy. He co-edited Lost, The Politics of Mourning in 2003, and was the co-editor of the Lambda Award-winning Q&A, queer in Asian America. Please join me in welcoming Professor David A.
Thanks, Devon. I want to thank Russell Robinson and Saul Sarabia and Devon and the other panelists for allowing me to join them today and for the invitation to be here. I'm very inspired by your analysis of the personal ads, and I can only say that, you know, gay people have always been able to embrace their racist and homophobic desires in a way that could be instructive to us all. I was at a performance the other day, the Slanted Eye Mamas. I don't know if any of you have ever seen them. They're a two-person group, and they do this kind of jam, and they actually talked about Abercrombie and Fitch. So, you know, the whole thing with two wrongs can make it white. They had a great phrase, and they turned it around, two whites can make it wrong. So that's kind of funny, no? All right, so let's get serious. Right, it is funny. All right, so my talk is really organized into two parts. My quick talk. The first, I'll analyze Abercrombie and Fitch's advertisements as a kind of racial hate speech that flies in the face of equality. And second, what I'd like to do is to pursue an intersectional analysis of the white racial and homosocial content of these advertisements to suggest that in our putatively colorblind age, homosexual equality does not require racial diversity. And I'll end with a brief analysis of Lawrence v. Texas in order to illustrate how this dissociation of homosexuality from race works in this landmark 2003 Supreme Court ruling. And I describe this dissociation as queer liberalism in a colorblind age, which is the title of my talk. In only words, Catherine MacKinnon observes that constitutional guarantees to free speech and commitments to racial equality do not go hand in hand. Indeed, they are more often at odds with one another. MacKinnon writes, quote, "The First Amendment has grown as if a commitment to speech were no part of a commitment to equality, and as if a commitment to equality had no implications for the law of speech," end quote. MacKinnon's legal arguments famously concern not racial but sexual discrimination, the regulation of heterosexual pornography. Pornographic images, she argues, are not only words, but are in fact performative. That is, they not only say, but also do something. They not just represent women from a particular misogynistic perspective, but more importantly, they function as a type of hate speech directed against women, demanding their abuse and continued subordination. As such, pornography should not be protected as expressive freedom, but regulated as sexual discrimination. Like the judge who declares a couple man and wife, or the security guard who tells the attack dog to kill, pornographic images are not speech as ideas, but speech as harmful action. MacKinnon writes, quote, "In pornography, women are gang raped so that they can be filmed. They are not gang raped by the idea of a gang rape. It is for pornography and not by the ideas in it that women are hurt and penetrated, tied, and gagged," end quote. I'm not going to debate MacKinnon's views on pornography today. A lot of ink has already been spilled on that particular topic. Instead, I would like to resituate MacKinnon's theoretical insights in the context of Abercrombie and Fitch's advertising campaigns and the company's discriminatory hiring practices. In Abercrombie and Fitch, we are presented with a rather blatant example of what I might describe as a type of racial hate speech. That is, Abercrombie and Fitch's advertisements, roving gangs of young white men, scantily clad and frolicking in the fields of homosocial desire, is decidedly performative. It is performative insofar as it not only commands $1.7 billion worth of consumer spending per year, it also demands racially discriminatory hiring practices. Unsoiled white fraternity and sorority are the face of the company's sales force, treasured and promoted, while people of color are resegregated, consigned to the back of the stockroom, or literally outside the store, washing down the windows. As such, the consent decree in the legal settlement is exceptional insofar as it implicitly acknowledges a negative relationship between the corporation's right to free speech and questions of racial equality. Remarkably, in addition to establishing mechanisms for more employment opportunities for people of color, The company also agreed to diversify its advertising campaign so as to include more multicultural models on their shopping bags, posters, and store catalogs. And I know that Cheryl and Jahan are going to be speaking about the consent decree and what happened subsequently, and they'll be presenting you with these beautiful images soon. We might cynically read this consensual settlement as a public relations ploy. Abercrombie & Fitch diversifies its image out of self-interest with a few whitish folks of color to prove that they are not racist. Nevertheless, given the fact that the court has historically protected the free speech of the economically dominant, of corporations in the marketplace, over the claims of the racially disenfranchised, this settlement is no small victory. Insofar as it draws attention to racial equality as an issue with serious implications for the law of speech, the case resists the dominance of the economic and its configuration of the market today as our sole source of racial salvation. The truth of the matter is that Abercrombie & Fitch does not at all present an anomalous example of the invidious racial effects of corporate advertising in a colorblind age. Rather, the idealization of a homosexual white fraternity in Abercrombie & Fitch belies a racial logic that is entirely common to neoliberal principles of global capitalism, one insisting upon the corporation's right to free speech as an issue of not just the market, but indeed as the source of anti-racism. That is, in a post-Brown and Loving moment, racial equality is increasingly considered as a set of economic choices in the free market. Neoliberal policy is seen as the key to a post-racial, colorblind world of freedom and opportunity. This logic permits critics, conservatives and liberals alike, to dissociate race from politics. It also allows them to take umbrage at the consent decree precisely as an infringement on Abercrombie & Fitch's right to free speech in the harmonizing world of the free market. Take, for instance, this typical reaction in the Daily Targum, the campus newspaper of Rutgers University. Quote, "To me, this isn't a matter of racism, so let's stop trying to make it one. Each store has its own target audience it wants to appeal to, and thus its marketing should be and is reflective of its target audience. Allow FUBU to continue to market to the black buyer and Abercrombie & Fitch to market to the white buyer. After all, both races are free to wear either clothing brand they choose. As a result, let's take a step back, especially at the NAACP, re-examine the situation, and realize equality does not necessarily call for diversity, but rather a level playing field," end quote. So let's take a step back, re-examine the situation, and realize equality does not necessarily call for diversity. I choose to cite this rather unextraordinary opinion piece to emphasize one crucial fact. In our colorblind age, we have decidedly taken a step back insofar as equality today most certainly does not call for diversity. Let me proceed then to my second point, an intersectional analysis of the racial and homosocial dynamics of the Abercrombie & Fitch advertisements. Many have observed the effects of Abercrombie & Fitch's branding on gay men, indeed gay men of all colors, raising the possibility that gays, no less than straights, are beholden to an oppressive racial logic of idealized whiteness. This observation, as my students would say, is no big newsflash. A quick glance at the gay personals or of any random website would confirm this fact, even to the deaf, dumb, and blind. Nonetheless, I think an intersectional analysis of the homosocial whiteness of Abercrombie & Fitch reveals a more subtle and complicated racial logic at the heart of our colorblind age. Today, neoliberal mandates posit gay equality precisely as that which refuses racial diversity in the name of an official anti-racism. Elsewhere, I have written in detail on what I call the contemporary emergence of queer liberalism. This is a particular coming together, I suggest, of the neoliberal economic principles with the politics of recognition that form the basis for liberal inclusion of gay and lesbians conforming to their mandates. The merging of an increasingly visible and mass-mediated consumer queer lifestyle with recent legal protections for gay and lesbian rights to privacy and intimacy established by the landmark 2003 court ruling Lawrence v. Texas, as well as Massachusetts legalizing of same-sex marriage in the same year. And what we have to recall here is that the Abercrombie & Fitch case was filed the same month that Lawrence v. Texas was decided, right? They're historically coterminous. Approached from this angle, queer liberalism's appeal to, rather than defiance of, the state marks a significant moment in which the politics of queer nation and U.S. citizen are no longer at odds, a fact evident in the astonishing August 2004 coming out statement of former New Jersey Governor James McGreevey. And if you remember, what he said was, quote, "My truth is that I am a gay American," end quote. It is, of course, difficult to resist interpolation as law-abiding citizens, capable of relationships and intimacy, no longer constitutionally criminalizable, worthy of national belonging, and deserving of judicial respect. Yet decriminalization and social enfranchisement are not one and the same thing. As such, it would be premature to embrace queer liberalism, to embrace wholeheartedly what Lisa Dugan labels homonormativity, the gay and lesbian liberal platform advocating for progressive causes such as same-sex marriage, while rhetorically coding freedom, liberty, and equality in the narrow language of privacy, domesticity, marriage, and the unfettered ability to shop until you drop. In such a context, it is crucial to note that the historical emergence of queer liberalism depends on the completion of racial equality as a narrative of liberal progress. This dissociation of queer liberty and freedom from racial equality is everywhere evident in Lawrence v. Texas. Here, let me remind us that the plaintiffs in Lawrence, John Geddes Lawrence and Tyrone Gardner, were a mixed-race couple. According to legal scholar Dale Carpenter, they were not a couple at all, but actually part of a vexed one-night love triangle. Why then should we not approach the case as an enduring symptom of the U.S. nation-state's inability to deal with its ghosts of miscegenation, rather than as an unadulterated victory for queer liberalism? Let us recall it was not the report of consensual homosexual sodomy that provided the legal basis for the Harris County Sheriff's Department's intrusion into Lawrence's Houston apartment. In fact, it was the report of a weapons disturbance. Carpenter tells us that Robert Eubanks, the jilted third in the Lawrence-Gardner love triangle, called the police with the following words, quote, "There's a nigger going crazy with a gun," end quote. Justice Scalia observes in his scathing dissent that non-enforcement of same-sex sodomy laws does not prove that they are outdated, as people do not often call the police when their neighbors are doing the nasty. Scalia is right. People do not call the cops when their neighbors are getting it on. They do, however, call them when they see an unidentified black man on their property, and under such circumstances, the police always respond. It is this enduring and far from resolved history of whiteness as property and black racial trespass through which the queer liberalism of Lawrence emerges. How is it, we might wonder, that what begins as a story of racial trespass can end as a narrative of queer freedom? Let me conclude this brief analysis by noting that Justice Kennedy's majority opinion, as well as the Scalia dissent, both invoke the 1967 Supreme Court ruling Loving v. Virginia, in which the court held it unconstitutional for Virginia to allow a white person to marry a white person, but not for a black person to marry a white person. I am fascinated by both Kennedy and same-sex marriage advocates' continual analogizing of homosexuality to race, the ways in which they insistently compare current public resistance to same-sex marriage in relation to outdated miscegenation laws. As the stigma against mixed-race couples proved legally untenable in 1967, so too will social and legal resistance wane against same-sex marriage in our present moment. By analogizing same-sex marriage to the settled history of interracial union, queer liberalism is thus embedded in a narrative of temporal development and progress. In short, racial liberation is configured as a politics of the past, while queer liberalism is configured as a politics of the present. In this manner, we witness a cleaving of queer from critical race politics, and from this perspective, it is no surprise that the Lawrence ruling is followed only a week later by the Grutter versus Bollinger and Gratz versus Bollinger decisions, signaling the imminent demise of affirmative action. Queer liberalism's historical emergence simultaneously underwrites affirmative action's premature end. In this manner, as our Rutgers columnist suggests, homosexual equality does not necessarily call for racial diversity. In the age of queer liberalism, it refuses it. Abercrombie and Fitch's world of homosocial whiteness describes more than just an advertising fantasy. Their pictures are us. Thank you.
Thank you, David, for that wonderful presentation, and thank you as well for staying squarely within the 15-minute time frame.
14 minutes.
14 minutes.
Even with my joke.
even with your joke, which was very funny. So we have a wonderful indication of how we might think of the adverts that Abercrombie and Fitch provides, and we'll see some of them in a moment, how we might think about them as raising questions that implicate both the 14th Amendment and the First Amendment, that is to say, speech-like questions. In fact, though, the case was not litigated around those specific doctrinal regimes. So what we want to do now is begin thinking specifically about the way in which the Abercrombie and Fitch case was litigated, ask ourselves questions about the settlement, and whether the settlements are sufficient to the task of dealing with some of the images that you will see. To help us through that, we have, happily, Jahan Sagafi, who is a partner at the law firm of Lieff, Cabraser, Heimann, and Bernstein, and was also directly involved in the litigation. After completing his law degree at Harvard, Mr. Sagafi completed a federal district court clerkship. Currently, he's on the executive committee of the litigation section of the State Bar of California, and on the executive committee as well for the Constitution, the American Constitution Society. A board member of the ACLU of Southern California. His practice areas include employment law, consumer protection, mass torts, and antitrust. Please join me in welcoming Jahan Sagafi.
Alrighty, thank you. Thank you, Devon, and thank you, Russell, and Saul, and UCLA for your hospitality. It's wonderful to be here. My name is Jahan Sagafi. I'm with Lieff, Cabraser, Heimann, and Bernstein in San Francisco. We're also in New York and Nashville. We are a plaintiff's firm. We represent individuals against companies, mostly in class actions, in a variety of different areas, including employment discrimination cases like the Gonzalez versus Abercrombie and Fitch case, and consumer cases, securities cases, products liability cases across the board. So to pick up on Devon's intro earlier, I am a corporate acting, corporate looking lawyer, but I am not a corporate lawyer. So to you law students in the room, I think there are quite a few law students and young practitioners and academics and future academics. I'm going to give you a different perspective from the rest of the panelists, I think, in being a practitioner who is not well versed in the subtleties of a lot of these theories, but we just kind of go out there and get stuff done. I certainly don't mean to disparage theory by any stretch, because we do work hand in hand, and we need academic theory to advance an understanding of where the law should be and where the law can be, and how as a society we can move forward. But I think that I'm thinking of you future practitioners who, like me, may not be quite smart enough to be academics, but will go out there and try and do something useful with your lives. And so you do have a choice to fight for individuals, for companies, for Eddie Gonzalez and the rest of the plaintiffs, or for Abercrombie. And that's a very, very important choice. And I think from my law school experience and your law school experience, perhaps you'll see that a lot of the companies, a lot of the firms who represent companies like Abercrombie come and they wine and dine you and they wow you with their impressive resumes and cocktail parties. But there are other places to go. So if anybody is interested in that kind of thing, in that kind of future for yourself, certainly I'll stick around and I'd love to talk to you, and you can reach me by email or however you wish. Let me just grab this guy. I'm going to give you a brief overview of where we went in the litigation, starting with what we first saw of the Abercrombie look that I think you all are fairly familiar with, and I'll give you some examples of that. Overview of the litigation itself, and go into the settlement and the consent decree that we entered into, which has a 6-year term, so we're now about 2.5 years into those 6 years and still fighting to ensure that Abercrombie improves its hiring practices, summarize the achievements that we've made to date, and then hint at some of the limitations that have already been pointed to here, and we're going to explore as a panel as we go, because there are some things that we can tackle and there are some things that we can't. But you'll see as it unfolds that essentially ours is a very conventional case where Abercrombie is discriminating in its employment against people of color and not hiring people and not promoting people and not assigning people the hours that they should be, and that was based on race, and that was linked to their marketing. But it was not self-consciously directed at changing their marketing. We viewed their marketing essentially as an employment manual, or as a tool that they use to enforce their ideas of what their employment should look like. So there has been this divergence as Abercrombie has improved pretty dramatically in its hiring of people of color over the years. And that has been the good story, and the bad story is the marketing is essentially unchanged. So we'll get into that. And before I start, I wanted to recognize that Professor Jyoti Nanda is here, and she was my co-counsel on this case, and she worked at NAACP Legal Defense Fund, so I wanted to give her a round of applause for her work in that. And thank you for inviting me. And also one of the real heroes of the case, Anthony Ocampo, is back here. He's a PhD student in sociology. He was one of the dozen or so named plaintiffs, along with Eddie Gonzalez, his fraternity brother, who made this case happen. So I wanted to recognize Anthony's role in bringing justice for all these thousands of people. So let's talk about the Abercrombie look. This may be familiar to you. This is essentially the Abercrombie look. These images are taken from their quarterly, which was their catalog / marketing material from 2002, 2003 when we brought the case. And you can go through page after page after page of silly white people looking very self-satisfied. I think that picture really kind of sums up Abercrombie. And so you've got these white models, person after person after person, a little risque. And then every once in a while you stumble upon a person of color. And so right there in the crease you can see this person just trying to scramble out and get herself a fair opportunity. And then she appears again. She looks a little bit uncomfortable on the left, but then she's getting on board on the right there. And then there's another one that stuck out. I looked through about 5 quarterlies from 2002, 2003 in my office when I was trying to select these pictures. And that was the best one of people of color that I could find. And it was pretty telling that they were on the outside of a window looking in, looking kind of, afraid as opposed to randy or whatever. Then there were also the T-shirts, and there's an interesting lesson, I think, in the T-shirts. There were 2 fairly famous T-shirts back in 01, 02, and this is the Wong brothers, 2 Wongs Can Make It White, with very offensive stereotypical pictures of Asian Americans. The Asian American students organizations, just before we got our case going, made a real big stink nationwide among their membership and in the press generally about how offensive these T-shirts were. And I found this pretty easily on Google. But there was an equally offensive one that had a donkey wearing a sombrero that said something like "Take Juan, Juan, for the road," and it was this kind of anti-Latino thing. And I think they were both sold around the same time, and it didn't make as much of an impact in the press. And I couldn't find it on Google either. And so I think it highlights to me the difference in the effectiveness you can have in a media campaign as students. And young people when you're trying to go out there and raise awareness about something that a company has done wrong. Because I think this one happened for whatever reason of organization and outreach to make a bigger splash. So there's also a lot of homoerotic imagery that we're going to pick up on here that shows you a different side of the fraternity of Abercrombie. And then there's also one where they kind of take this approach of the sort of casual, privileged, rich, comfortable white person and they had a mock demonstration in one of their quarterlies that had all these odd signs and signs that were sort of supposed to be political, but they weren't really political, and so they're just kind of making fun of the concept of activism, which is a very useful concept for Abercrombie because it subverts the energy that we're trying to put around change. So, in the litigation, back in 1999, a guy by the name of Juan Carlos Gomez Montejano worked at Abercrombie and was stuck mostly in the stock room and then had his hours cut without any explanation, and he got upset about it, and he went to MALDEF, the Mexican-American Legal Defense and Education Fund here in LA, and enlisted their help to file a charge with the EEOC, and that started the process. The EEOC made a finding that Latinos and blacks as a class had been discriminated against, which is pretty unusual for the EEOC, because much as we would like to believe in our government, and I suppose we don't that much anymore, but the EEOC doesn't usually get itself going on the side of plaintiffs. They usually just try and keep you from causing trouble and just process your charge and get you out of the way. So that was a somewhat significant finding. MALDEF reached out to us, and we reached out to APALC, the Asian Pacific American Legal Center, and investigated this. That's how I met Anthony, and we found that this look was translated into hiring practices wherein people of color were suffering discrimination in a variety of ways that I'll go into. We filed the case in June 2003 in San Francisco in the Northern District of California. We got the best judge we could possibly get, who's a former plaintiff's lawyer, Judge Susan Ilston. She oversaw our case against Home Depot. That was a gender discrimination case that settled for, I think, $87 million in the early 2000s. And getting her as our judge was a really, really powerful sign of good things to come, because these judges will make or break your case if you're in the right venue, if you're in the right circuit. If we were in the Ninth Circuit, being in California, we knew we had good law and good judges. Under the Bush years, that gets eroded, that changes. You get worse and worse judges, and you start thinking, oh boy, this case isn't worth as much anymore. Another example is the gigantic gender discrimination case against Walmart on behalf of women. That's been reassigned from an African-American judge, Judge Jenkins, to a very conservative Reagan appointee, Judge Walker, and people are a little concerned about what that means. So essentially, Abercrombie was discriminating in its recruiting. They were going to fraternities and sororities and sports teams that were predominantly white. In their hiring, they'd have a group interview. They'd just kind of look at everybody and pick the people that they liked, that looked like them. They had a huge problem assigning white people to be the brand reps on the floor and people of color to the stock and overnight positions, and then they just had fewer and fewer people of color up the ranks. When a person of color would come and ask for an application, they'd say, oh, you'd be great for the stock room, or you should be an overnight, or we don't have any applications anymore, or we're not hiring. And then their white friend would come and they'd say, oh, you'd be perfect as a brand rep, so we'll hire you. They'd have corporate blitzes where the CEO and high-ranking corporate officials would come, and they'd look around and they'd weed out the people that they thought didn't fit the Abercrombie look. Another huge problem that we focused on was the subjectivity in their hiring practices. They weren't really hiring people based on performance. They were hiring them and promoting them. They were hiring them based on their look. And when they would instruct their managers, hire people who look like you, hire people who you like, hire people you would hang out with, that's a very amorphous kind of thing. But when you're telling it to a bunch of white people and you have a bunch of white pictures on the walls, they get the message and they know what to do. Discovery is the meat of litigation, and it's so boring I shouldn't even spend a whole slide on it. So basically we went through a tiny, tiny number of documents, which is 17,000, so that gives you a picture of what we have to live through as litigators. And we talked to a ton of witnesses, and witnesses coming forward and sharing their experience was crucial to our being able to achieve a great settlement. So we negotiated the settlement over the period of 8 months, many mediation sessions, and we sent out notice to about 320,000 potential class members, because we couldn't know who all the class members were because they had thrown away the applications of the applicants. So we sent it out to all the people who had worked at Abercrombie, and then also people that we could find who might have been class members. And we sent out $40 million to about 16,000 people in this claims process. Now, more important than that is the consent decree, which is this 6-year decree that has created hiring benchmarks. So we essentially moved Abercrombie from about 9% people of color in the brand rep position to now about 30%. When we were litigating the case, 30% was the market in terms of what the Gap and J. Crew and American Eagle were hiring. Now that market has moved as we become a more diverse country, so 30% is still lagging behind, but a dramatic improvement. They also had to create an Office of Diversity with the Vice President of Diversity. They have diversity recruiters who create relationships with organizations so that they can reach out to people from more diverse backgrounds than just the white guys from the water polo team. That we also revised their hiring practices so that they have to hire and evaluate people based on their performance, not based on their look, and made a few other important changes. Now at the bottom, we had a small little tidbit there about their marketing materials. Marketing materials was near and dear to their heart. They did not want us to mess with the marketing. And so the best we could negotiate was that their marketing materials must, quote, reflect diversity as reflected by the major racial, ethnic minority populations of the United States. So big question, what does that mean? We're in the middle of fighting that out now, and we're gonna see if we can put some teeth into that because their marketing, as I said, has essentially not changed. One little idea that I had is this IAT, the implicit association test. I asked them if they would have their employees take the implicit association test, which I highly recommend. A lot of you are probably familiar with it, but if you check out that website or if you just Google IAT or IAT Harvard or something like that, it's a very quick little 5-minute test that you can take to gauge the implicit associations you make between women and being bad at science, or black people and crime, or whatever the various associations that are built in our society, and they can play out when you have a subjective hiring process that's not focusing on did this person show up on time, does this person know how to fold clothes, does this person do their job well, but do I like this person? And then you have this subjectivity, and then you end up going with people that you have implicit associations with good things with. So they haven't bought that, but I recommend it for everyone because it's an interesting exploration in self-knowledge. So as I said, they've moved from about 9% to 30% minority. In addition to the $40 million that we've distributed to the class members, just moving from 9% to 30% is maybe about $114 million of value that we transferred from people who would have, white people they would have hired, to people of color. So the problem remains the marketing. And as I said, we're going to fight that out with them. There is a monitor who's a neutral lawyer who used to be an EEOC commissioner who's been assigned to oversee the case, and he collects feedback from people who call him, and he goes into the stores and researches, and he talks to Abercrombie corporate employees and so forth. If anybody has any strong opinions about Abercrombie's hiring practices or their marketing or the link between them, feel free to call him. I will give you his number. His name is Fred Alvarez. He works at Wilson Sonsini in Palo Alto, and he and his coworkers try and figure out what people on the ground are thinking about how this marketing affects the hiring. One good thing that they did do in terms of trying to de-link the marketing from the hiring is we asked them to create an image book that they could give to managers that would show people of color and white people together as these are people who have the Abercrombie look. These are the people that you should be hiring. And it's a very diverse book, but it's probably doesn't have the effectiveness of all the posters on the walls. So it's unclear whether that's having, what kind of effect that has, although they are up at 30%, so it perhaps has some kind of impact. So just to wrap up, there are limited things that we can accomplish as practitioners, but those accomplishments I think are real as measured by the dollar value that we transferred to people who deserve a fair opportunity to compete. And then there are other opportunities like publicity and boycotts, and then we'll have to think about what else we can do. So that is all I have, and I'm
Thank you, Jahan, for that wonderful presentation. Clearly, Jahan's presentation, along with David's, makes clear that the face of Abercrombie and Fitch is not terribly diverse, and one way to think about the problem of imagery is the extent to which one is excluded. Another way to think about it, though, is to ask questions about whether there is both an inclusion or an exclusion, or to put it slightly differently, whether there is a process by which black cultural identity or black cultural production more generally is both appropriated on the one hand and discarded on the other. And to get us thinking about those issues, I introduced Phillip Goff, who is an assistant professor of psychology and coordinator for the Africana Research Center's postdoctoral fellowship at Penn State University. His research on stereotype threat demonstrates that the threat of being perceived as a racist can have the deleterious effects of both producing racial discrimination and encouraging the endorsement of negative racial ideologies. His work on the intersection of race and gender investigates how identity processes can affect discrimination. He is the author of Can Science Help Solomon? Child Maltreatment Cases and the Potential for Racial and Ethnic Bias in Decision-Making. I'm not sure whether science can help Solomon. I am sure that Professor Goff can help us. His presentation will focus on the ways in which black male sexuality can be picked up as cool on the one hand and treated as both dangerous and violent on the other. Please join me in welcoming Professor Phillip Goff. Let's see what we can do.
Wow, it worked. Wonderful. So I, too, would like to thank the folks at UCLA, particularly Russell and Saul, for having me out here, and the wonderful panel. I am your boring statistics lecture in the middle of the gifted speakers. So I apologize for that in advance. I am a social psychologist, so having no other marketable skills, I will have a dazzling PowerPoint presentation. Though I am not from, technically, a black preacher background, I am of the tradition, so as we move along, given that this is an interdisciplinary audience, I may ask for some call and response. You don't have to amen, though occasionally it's encouraged, but do let me know that you're with me, if that's all right. Is that all right? Thank you very much.
Amen.
Okay. That is my first of what will, I'm sure, be many cheap applause lines. So my talk today is entitled Hung Like a Black Guy, Notions of Black Male Cool Across Social, Sexual, and Criminal Justice Contexts. As Devon sort of said in his introduction, I'm also the person not speaking directly about Abercrombie, but I am speaking about identity and brand. And I'm hoping that the connection will seem obvious as we move to overlapping. So if we imagine black male cool as a brand, what does that really look like? Okay? Well, we would say it's self-assured, it's some kind of rhythmic component, musical, and certainly sexual or hypersexual. You think about Miles Davis, who is the icon of the cool jazz era, right? And that became a brand. You think about Michael Jordan, who used his cool to sell sports drinks and shoes. But when an identity becomes a brand, then people must be able to purchase it, which means they must be able to see themselves inside of it. They must be able to be like Mike. Which becomes perhaps empowering for some, problematic for others, and others can find a way to rule the world. The question then becomes, when you're talking about an African-American cool brand, how is it that you have perhaps one of the most reviled social identities, that of African-American males, becoming a coveted brand for dominant group members? Right? There's an eminent social psychologist who says a great deal about this, from which the title of my talk is taken. I'd like to share his words with you, if I might. The social psychologist is named Paul Mooney. Uh-oh. Well, it's supposed to be named Paul Mooney. Let's try this again.
Volume button, I think, on the console.
You know what? I think the mute button's on.
Okay.
No?
Uh-oh, that's pretty mute.
This is not counting against my time. Huh? Is there a sound on the wall? You have no idea. I can't tell this. Paul got to tell me.
So why don't you just lift us on maybe?
Yeah, the sound is connected.
Is it connected in the room?
There are two ports. Is it in the earphone port or the sound port?
It's in the earphone port.
Yeah.
That makes no sense.
I don't know. I'm not as technical, so.
Get out of here.
Try it again.
Yeah, it's in the headphone jack. It's in the right spot. Hold up, hold up.
Somebody should try it.
Turn that up, turn that up. Thank you very much. I'd like to again thank Saul for standing there. It's a team effort. So again, the eminent social psychologist, Paul Mooney.
I was in the goddamn world. She was sick. A white man walking on the beach, finds the magic lamp, rubs it, a genie pops up. Look, I've been in there 300 years. I don't want to hear any talk. You got 3 whistles, just think it will happen. Big magic. Naked women running over the magic. Knocking the door. 3 Ku Klux Klan dressed in robes, taking a man out on lynch. Next to the Jesus Starbucks talking, so they all go down the coffee. I was gone for 300 years, nothing's changed. They all want mansions, they still want mansions. They all still want naked women, but the third wish is very confusing. Why would he want to be hung like a nigger?
Okay. So the punchline rests on this dichotomy. There is violent policing of black male cool when black men are doing it, yet it is a coveted brand for white men, occasionally in Paul Mooney's world, ending in some tragic consequences. So that dichotomy and that ironic, perhaps hypocrisy, is basically the root of what I want to be talking to you about today. I'm going to divide this into 2 sections. I'm trying to move fast enough to get through both. In section 1, I want to talk about how white students conceive of this black male cool brand and to what effect, to what effect they employ that brand. And in section 2, I want to talk about how African American males are perceived when perceived to be embodying this brand, both in laboratory effects and in the real world. Okay? So again, I'm going to do this using social psychological experiments. I'll try and go light on the statistics. I see some of my psychology brethren and sistren. Please ask me about that afterwards. So in our first study one, which I'll entitle What's My Jam, we asked 169 white Penn State undergraduates 2 very simple questions. What is your favorite genre of music? We gave them the options that are on Billboard's genres of music. 73% say rock and roll. The second question was, what is your favorite genre of music when getting to know that special someone? 78% said rap or hip-hop. Okay, so this was interesting because either the same students, they answered both questions. So they're saying, I like rock, except when I'm in the mood for love. So we asked a number of respondents, well, why is it the case that you answered rock for the first and rap and hip-hop for the second? One male respondent who was very forthright said, I can't get a girl to grind on me bumping country music. Lest you think that he was alone, one female respondent said, I don't want some guy grinding on me to Sweet Home Alabama. We're discovering psychological universals here. Okay, so in study 2, we wanted to see whether or not this actually sort of undergirds the psychological processes when people are employing brand performances. Okay, what we did, we took 28 white male Penn State students. We told them, you're going to have a conversation with an attractive, white, female, heterosexual partner, okay? You're going to be talking about love and relationships. And we gave them information about what kind of partner this female tends to like, right? It was either a manly man with a manly scent or a sensitive guy. They then got to choose what kind of mood music was going to be on when they got to have the conversation with the attractive female coming in from the next room. Okay. What we hypothesized was that in the manly man condition, that's a good time to perform blackness. In the sensitive guy condition, that's a bad time to perform blackness. Again, relatively straightforward. My chart here does not want to show up because today is the day of multimedia disasters, but that's okay, because I think I know how to solve this one. We double-click on this, we quit out of this. No, that's not the way. There we go. Hey. Lovely. So, over on the left-hand side, this is the number of people who were selecting this particular type of CD. This is for the manly man, this is for the sensitive guy. The white bars will be for rap music, and the dark bars for rock music, right? So when they're talking to an attractive female who likes a manly man, they prefer rap music. Not so much when she prefers a sensitive guy. Okay? So this is the strategic deployment of African American cool for a particular outcome. And for the social psychologists in the room, on a me, not me task, they associated themselves with African American and imagined that they were going to be more successful in the interaction when choosing rap rather than rock music in the manly man condition. Okay? But to be a manly man, one must first be considered human, which has not been an assumption made of African American men throughout the entirety of struggle towards equality. I have here images from the 1968 Memphis sanitation workers strike. This is not just about asserting humanity, but it's about resisting particular dehumanizing images of African Americans. And a good portion of my work up until now has been demonstrating an implicit link. I'm glad that someone was talking about the IAT before I got up here. The implicit link between African Americans and apes. And the implicit link between African American and apes can be traced back to early work in anthropology and early maritime, where African Americans are seen as somewhere between apes and whites along an evolutionary scale. And this ape-like representation comes with it a particular addendum, which is the predatory exposure to white women. Okay, we see a recruitment flyer for the U.S. Army in World War I. We see the 1933, the first ever summer blockbuster, frequently interpreted as an allegory or a cautionary tale against interracial romance, King Kong. We know who the white woman is. That must be the black guy. And we see this recapitulated, okay, to billions of dollars and several Oscar awards. Okay, so we'll call this the Negro ape metaphor because that's what Tommy Locke called it. This is a persistent implicit bias or an implicit association that not just whites, but most people in the United States who are past first-generation immigrants hold, associating African Americans with apes. The representation has been used to explain African Americans' violence, dimness, and sexual predation, which is the part I'm going to talk about most. It's also been used to justify anti-black violence, particularly in the context of lynchings. I'll spare you guys the pictures and the videos, but most students of history will know what I'm talking about. Right? Okay. So in study 3, we wanted to look at this King Kong effect. What I mean by that is this myth of black male hypersexuality and sexual predation, which is part of the brand of black male cool. That's what I've discussed it. This myth has two key components, which we used in pre-testing. Ever want to do pre-testing on something that's going to make you feel uncomfortable? Ask a bunch of undergraduates what the components of black male sexual prowess are. The first is that they have access, particularly to white women. That is, white women like them. Second, that they are particularly well endowed. All right? The questions that we were asking, will white men continue to be threatened by this particular mythology? And will this threat continue to have violent consequences? 5 minutes. I got to talk fast. So we took 31 white male Penn State undergraduates. We brought them in. And we told them, hey, it's true what they say about black guys and white women like it. Or it's not true what they say about black guys and white women hate it. I'm serious. That's really what we did. They then did a masculinity word search. They then watched a video of a police beating, and I'll tell you why, a particular police context in a second, and were asked how justified is that beating, and then they took a dehumanization implicit association test, which is basically implicitly how much are you associating blacks with apes. Okay, so the masculinity word search, if you right now are feeling like your manhood is not really intact, these words might be jumping out at you. Okay, the number of words found, I didn't see it before, you can see it now. The degree to which people are finding these words in a word jumble like this is an indication that they are vigilant to threat cues, right, and that their masculinity might be under threat. This is the video they saw of the police beating.
The following film documents the police arrest of a suspect believed to be involved in an armed robbery, June 17, 2004. Though his family describes him as a loving husband and father, his police record indicates a history of drug involvement and criminal violence. According to police reports, the suspect was believed to be under the influence of a mind-altering drug, possibly PCP, at the time of this filming. The police report indicates that the arrest followed several days of tracking the suspect and a lengthy pursuit on foot.
Detaining suspicious.
So after viewing this clear example of police brutality, they're asked, how justified was the beating? All right. Rather than wasting time trying to figure out why my PowerPoint is upset with me, let me tell you that in the myth condition, when we told them it's true what they say about black guys and white women like it, the IAT effect is more than doubled. You'll have to take my word for it. You're going to do this to me on all of them? No? All right, good. In terms of masculinity threat, all right, this is the number of masculinity threat words that were found in the word search. Again, the white bars are going to be the no myth condition, the gray bars in the myth condition. And what do we find? More than double. Okay. By the way, we've replicated this substituting Asian men and Latino men, and we don't get these effects. So this is particular to the black male brand. Mm-hmm. Last and most importantly, how justified was the beating? This is on a scale of 1 to 7, so 4 is the midpoint. Okay, where they say, neither justified nor unjustified. In the no myth condition, we see that they're saying it's unjustified. In the myth condition, it might be all right. So I want to talk about why we chose a policing context in particular, and in an LA audience with regards to these quotes from an LA dispatch to LA County police officers. Evidence of break-in and sexual assault, suspect likely gorilla in the midst. Victim found DOA, NHI, body is cold. NHI, altercation, negative on engaging, let's see if there's a body count. Gorilla in the mist, West Hollywood, stopped on suspicion. NHI suspected still in the vicinity, subdued with extreme prejudice. Gorilla in the mist in Simi Valley, any 911 calls. Suspect died in altercation, NHI. To understand these quotes, you need to understand two things. First, gorilla in the mist is a euphemism for young African American males in majority white audiences, or majority white contexts. Second, NHI is a euphemism for young African American males. In any context, it stands for no humans involved. We wanted to take what we had found in study 3 from the lab to the real world. And I have just a couple of minutes left, so I want to run through this study, but I also want to pay it the respect that it deserves. What we did was we took 425 death-eligible cases in the city of Philadelphia between 79 and 99 from the David Baldus data set. David Baldus is a legal scholar and sociologist who compiled all of these death-eligible cases. A death-eligible case, for those who don't know, is a case where the defendant has been found guilty but has yet to be sentenced. The death penalty is on the table. Of these 425, 39 were white and 386 were black. That's a study in and of itself. We took a subset of these, 153, of which 15 were white and 138 were black. And Philadelphia is a unique context because it has one reputable print news source, the Philadelphia Inquirer. We coded the newspaper coverage for ape-related imagery. So the defendant mocked his victim by aping her screams or talking about life in an urban jungle. Right? So I want to talk about literally how images can harm. Really? Really? All right. I'll skip over this because the next one's the more important one. This is the difference between blacks and whites. I think you'll believe me when I say that blacks were represented as more ape-like than were whites. All right. Now what we want to do is take a look at the defendants who were sentenced to life versus the defendants who were sentenced to death, controlling for the number of articles, the socioeconomic status of both the defendant and the victim, mitigating and aggravating circumstances like the brutality of the crime, and whether or not the victim was a minor. What we see is that for those defendants who received life, they had an average of 6 ape-like metaphors in the press coverage, controlling for these factors. For those who received death, it was more than twice as much. So to be very clear, when one is represented as ape-like, you are significantly more likely to be put to death. And for those of you who are familiar with sentencing guidelines, you know that the people who were arbitrating this are not reading the press coverage. This is not causal. One of the few times when a psychologist can brag about it not being causal. What that means is that out there in the ether, in the cultural ethos, is this representation so coherent, so clear, that both the press and those who are deliberating over a person's life are drawing on the same sources such that one can predict the other. Okay, so to recap, black cool seems to be working out pretty okay for white guys, not so much for black guys. Now, what does that mean about the consumption of black cool brand? Is it an endorsement of white seduction? Is it an endorsement of black execution? And I would argue that you can't decouple these two things, not just given this research, but given the circle, and as to quote from Elton John, the circle of life, and in this case the circle of life and death, that consumption of images has in terms of outcomes for all. I'll end with my collaborators and say thank you.
Thank you, Phil. We'll continue this discussion of the ways in which black male sexuality or black male cool is both picked up on the one hand and discarded on the other. To help us do that, I now introduce Cleo Manago. He will link this process of appropriation and disregard to white people coming to terms with white privilege, including gay white men. Cleo Manago is a founder and CEO of the African American Advocacy, Support, Services, and Survival Institute, Amassi, non-profit community-based health, wellness, and cultural affirmation centers serving primarily African American and Latino men, women, and children in Los Angeles, in South Central Los Angeles, providing, among other services, preventative health care, STD care, and cancer. Manago is also the founder of the Black Men's Xchange, or BMX, and advocacy leadership development for social change for sane, gender-loving black males and their allies. Described as a social architect, an activist, a community organizer, an essayist, media commentator, and health and wellness expert, I guess a Renaissance man, Manago was a regular guest on BET's nighttime talk show, O Drama, and has been featured on Keeping It Real online TV. I'm tempted to riff on both the old drama and the Keeping It Real, but I won't. Instead, I'll just introduce you to give your presentation. Thank you.
Good afternoon. The technical people, let's get this set up the film. I also want to thank the inviters, which includes Professor Robertson, for guiding my path here, and Saul, who I met a long time ago. You know what I'm talking about. I'm a sensitive guy, so I'm still wowing from that presentation because much of what he talks about I lived through. Not lived through, but lived through. It's not over yet. So I'm going to try to compose myself and be professional and clear. My work, my mother's an attorney, so I do have a blood connection to the legal field. But my focus is health and human services, particularly mental health, particularly the mental health and self-concept restoration and rehumanization of people of color, with emphasis on black folks. My concern, or my major focus is on black people, because we've talked a lot about Abercrombie and Fitch and white privilege, all these things, but what often is not considered is the impact it has on people of color internally. For example, I spent a lot of time in Atlanta, Georgia, where there's an Amassi Center, and there's this big Abercrombie and Fitch sign in this predominantly black community. And we have to walk past the trauma of invisibility in our own community. And it has an impact on us that a lot of people don't understand, because sometimes we always focus on making sure that white people do stuff right and have white folks hire people of color and all that kind of stuff, which has some importance. But I'm still concerned because there's an issue that often determines what occurs when white people are in charge of hiring people of color, is hiring people of color based on their comfort zone, not based on black people's capacity to love themselves and be a healthy part of the milieu of people, of the diversity. You understand what I'm saying? That's my concern. This piece of footage here speaks for itself, and it talks about a contemporary example of the impact of white supremacy on the black psyche. And I think it speaks for itself. If it doesn't, then I'll add some things. But can we play this, please? This is a 2005 video, not 1965.
In Brown versus Board of Education, the famous case that desegregated schools in the 1950s, Dr. Kenneth Clark conducted a doll test with black children. He asked them to choose between a black doll and a white doll. In most instances, the majority of the children preferred the white doll. I decided to reconduct this test as Dr. Clark did to see how we've progressed since then. Can you show me the doll that you like best or that you like to play with? That one? I like to play with this. And can you show me the doll that is the nice doll? And why is that the nice doll? She's white. And can you show me the doll that looks bad? Okay.
That's enough, please. Can we stop it?
And why does that look bad?
Because it's black.
And why do you think that's a nice doll?
Because she's white.
This is unrehearsed, raw material from 2005, not 1885, not 1965, but a few minutes ago. This is the internal impact of ads such as Abercrombie and other things that I might go into in terms of the babies born into a soup that turns them against themselves and makes them feel like they're bad just because of this. This is happening all around you. Let me get this together. Again, I'm a sensitive guy, so don't be upset by me, my passion, please. Please address any concerns while I'm here or disagreements while I'm here. Often people gossip when I'm gone. I want to hear what you have to say. And please do research on all this yourself. Don't just go by what I say, because some of you might not believe this is true, like you might not have believed what I just showed you if you didn't see it for yourself, because some people don't. Thank you. Why should America, including gay America, see black people, Asians, Native Americans, or Latinos, especially those with dark skin, any different than Imus does? That's a question for you to ponder. It's not a rhetorical question. Speak among yourselves at some point. Like most mainstream American institutions, gay too is a white European acculturated affirming movement and social political construction. This has really been challenged, and I'm going to talk about that maybe later in terms of why that's really been challenged. Abercrombie and Fitch imagery and Imus's attitudes, for example, simply embody a racial perspective still quite present in America. So we like to talk about phenomena like Abercrombie as if it's this thing over there. But this is pervasive. It's here at UCLA too. When's the lawsuit coming? No, I'm just kidding. These are classic gay and lesbian symbology and images. Abercrombie fits in there too, so I put them up there because they look just like the rest of it. I went to a site called Gay Images. That's what it was called. There was no black people in it. Very few Latinos and hardly any Asians, except for this picture here. You'll see in gay culture people of color, but they always have to be with a white person. They never can love themselves. They never show each other embracing themselves. I'll talk about that a little bit later. But this is gay. This is gay symbology. The lambda from Greece, the pink triangle from Germany, Lesbos, the word lesbian came from the Sappho and the island of Lesbos. There's the island right there in case you're in the helicopter and you look down and you want to check it out. But this is gay. This is embodiment of gay. This is the symbolic track for this thing called gay, right? You've heard of this stuff, right? It's not just my blog. You've seen this. You have lambda clubs and lambda law firms, etc., right? Well, all of that stuff comes out of Europe. It has no affirmation of people that look like myself. And these are gay porn images. Again, this is not the 1965. This is, I tried to block out some stuff. I don't know if I did a good job. But it talks about, it's very objectifying, and it centers around white people's pleasure. The poor little white boy gets to have sex with a bunch of black men. The poor, more human person in the picture. Like white on rice. Speaks for itself. Can you cuss at college? I forgot. P-H-U-C-K, my black behind, bareback. Poor white guy gets gangbanged, and there's a black and white image there. This is part of gay culture, rarely ever challenged. And this is a very small sample. We would need a new computer to get everything in there that I saw. Given the existence of this phenomenon, what does gay rights really mean? Most queer, lesbian, and gay studies departments or programs are essentially white homosexual history courses. For example, who knows who Kabaka Mwanga is? Come on, students. I bet you there's some honest students here too who don't even know who Kabaka Mwanga is. Who are the gatekeepers of the Gara, the community in Burkina Faso? Who ever heard of the film Dakar? Dakan? Who ever heard of Nin Kuben and Komhotep? These people, one would think, would be part of so-called queer, lesbian, and gay history. You'll find out who they are in a moment. I have no problem that they weren't included because, as far as I'm concerned, gay is white anyway, and it's an affirmation of whiteness, and it's not where I get my affirmation anyway. So I'm not complaining. I'm just making a point of fact here, so you can see for yourself what's going on. Because none of that stuff called gay affirms people of color. Affirmation, particularly in the wake of oppression, is essential toward motivating, healing, and empowering a people. The HIV/AIDS industry failed and fails black people because it did not affirm us. And I'll break that down in a moment. Real quickly, when the HIV phenomenon was destroying black people, it was the white gay community was taking care of itself. See that? See those two symbols there? Those are the largest HIV/AIDS agencies in the country. What do you see in there symbolically? The triangle, because that's partly how the gays turned around the epidemic by affirming themselves culturally and symbolically, and it works. And they have been very successful compared to everybody in the world to turn around a major epidemic that was once in that community. But among the black community, it's still at epidemic levels. Who knew that? Who was Kabaka Mwanga? Well, I'm going to answer these questions. Kabaka Mwanga was the last king of Buganda who resisted British and Christian colonization. You guys call it Uganda now, but the people of that place called it Buganda. That's the indigenous name. Probably never heard of him. Numkomtep and Hotep are manicurists. Some things don't change from the stereotypes. They were a same-gender loving couple in the 5th dynasty who did hair and nails for the queen. And they were buried together, and you probably never heard of them either, but this is all, you can find all of this. And Dr. Malalomo Somé is from the Gara community in Burkina Faso, and they call same-gender loving people the gatekeepers, being that they have, as far as they're concerned, both male and female spiritual capacity and are more wise than everybody else because they have this double capacity, and they're often who people go to for counseling, etc. Did you know that? And the film Dakan is the first feature film on homosexuality from sub-Saharan Africa. It's been around a while, but because it doesn't affirm whiteness as a central focus, it's often marginalized, but it does exist. You know, you guys have the internet. And then there's the gay media that marginalize black-on-black love or people loving themselves. You ever 6 Feet Under? But the black guy was chasing the white guy all through the film. Dirty Laundry, black guy chases the white guy. There was a show called Rock starring Charles S. Dutton. Remember that? Remember Shaft? Shaft played a homosexual. He was chasing a white guy in that show. And there was a film starring Red Fox years ago with Norman, is that you? Heard that? And Della Reese. He was chasing a white guy. We don't like each other, supposedly. We don't chase each other. This symbol, I'm going fast because of the time here. This symbol is called the Bawabu. It's a symbol of the same-gender loving movement, which is an attempt among same-gender loving and bisexual black people to restore ourselves, to learn to love ourselves in our own image, and to heal from the scar of internalized oppression, externalized oppression and racism, etc. And it's a movement that's taken off that I can talk more about maybe during questions and answers, but it's a movement among black people who are same-gender loving where we're attempting to love ourselves in our own image and bringing our own cultural, indigenous ways of being as part of that framing, because it's a way of loving ourselves as we are, as opposed to loving ourselves through French and German versions of humanity. Since the inception of the same-gender loving movement in 1990, it's been embraced throughout the diaspora. There are same-gender loving websites, theories, conferences, community organizations, activities. Many of the gay pride celebrations are now called same-gender loving celebrations, and a lot of anti-homosexual attitudes in the black community have been transformed as a result of engagement with this movement. One of the more powerful examples that many of you might have heard about was when Minister Louis Farrakhan asked that there be same-gender loving or homosexual representation at the last Men's More Movement March. Who knew that? You knew that? Okay, congratulations. Now you have a record here. The importance of this, again, in terms of all that's here, is to get you to understand that not only do these white supremacist systems and activities hurt the landscape of alleged equality and having human beings be able to feel good about themselves, it does a lot of damage internally. Those babies in the very beginning of this film were randomly chosen. Nobody knew what they were going to say. Nobody knew what was going to occur. And like I mentioned to a woman I spoke to earlier, a lot of us are former children. Some of us are children in recovery. And a lot of those messages that we get have an impact on our worldview as adults, how we treat each other, how we see things. Like, it's my opinion, nobody asked, but that Barack Obama's success among whites has to do with him being half white. Because other black people have run before, other brilliant black people have run before. So some of us are happy that a black person is running. I'm glad to. I'm voting for him. I want to see what happens. But my point is that we really need to take a look at our internal world. Because if you work inside of Abercrombie, see, I didn't know anything about Abercrombie. I can't even say the name. What is it? I didn't know much about Abercrombie and Fitch in this whole case, because I'm all in the black community, and we not tripping off of this. Until we go down Peachtree in Atlanta and see that big old white boy every day when we trying to get to work. And what is that? But as opposed to speaking to you in intellectual fashion, like professors tend to do, I want to just keep it real. Not that they were not real, because my brother was quite real. He spoke to my heart. Everybody did, but I was one of those brothers getting beat by the cops before, so which ain't funny, so don't laugh. So I understand what it's like to be black in America every day for about, how old am I? Like 27 years. So, okay, 37. Anyway, any questions that you have for me, I'll wait for them. But think, let this stuff sink in. Think about your work is in the legal field. Think about if you're part of the problem or part of the solution. Think about if you're caught up in white comfort zone agendas as opposed to human equity agendas. Take a look at who you are, because some of us are in a trance, and we're just on automatic pilot and don't even know sometimes when we're being racist internally or externally. Thank you.
Thank you, Cleo. So now I really regret not saying something about keeping it real after your presentation. So there's a way in which we can think about the problem that Abercrombie and Fitch presents as one involving grooming. That is to say, what is the relationship between the grooming that we see in the ads on the one hand, the grooming of employees on the other, and employment discrimination still? Professor Cheryl Harris will help us think about these questions, and in that context, provide an indication of why employment discrimination cases are difficult to litigate, particularly when they involve issues of corporate branding. Professor Cheryl Harris is a professor of law here at the law school. She teaches courses in employment law, constitutional law, critical race theory, and civil rights. She has directed the critical race studies program here at the law school. She was also the recent recipient of the ACLU of Northern California's Distinguished Professor of the Year for Civil Rights Education. She has written far too many articles for me to list, including the groundbreaking Whiteness as Property. Please join me in welcoming Professor Cheryl Harris.
Thank you, Devon, and thank you to all of you for really a wonderful conversation. The only downside is that I have to get up here and talk now instead of being able to sort of chew on all of that's been said. I want to basically take up Abercrombie and Fitch, or whatever the name of the company is, at the intersection of law, cultural norms, and corporate culture. And my way of sort of thinking about this is to tell a little story about a film. So in the film adaptation of the book The Devil Wears Prada, you have to watch something when you're on the airplane, right? Actually, I watched it again because...
no need to explain.
I won't. My film watching habits are weird. The nerdy and decidedly unstylish young heroine of the film, who's a young journalism student who seeks employment with a leading New York fashion magazine called Runway, which is sort of a cover for Vogue, as a way to build her resume for serious journalism. There's a scene in the film where she just has this meltdown. Her job as a second assistant, she's an assistant to the assistant, of the CEO, style empress, and she-devil of the title, who the job proves to be hellishly demanding. And her inability to please her boss, to please the reigning queen, sends her running for comfort to the magazine's longtime head designer, a white gay man. To her surprise, he is decidedly unsympathetic. He doesn't offer her a shoulder to cry on. Instead, he points out that she has seriously underestimated the undertaking of Runway. He wants her to understand that it's much more than just a fashion rag. In fact, he argues it's a place where the greatest artists of the 20th century have worked, not simply in creating art, but something greater than art. That is, creating a world, an environment in which people aspire to live their lives. I want to argue that this is the corporate ideal, to be more than a recognized product, but to be a global brand in which people aspire to live their lives. And my contention is that Abercrombie & Fitch, I'll just call it A&F, is a global brand with more than 700 stores, 22,000 employees. John, I forget how much was it, whatever billion dollars?
They're over $2 billion.
1.7, close to $2 billion. From the standpoint of anti-discrimination law, this entity represents the perfect storm. It's a major corporate entity whose success is built around a particular and pervasive corporate culture. Corporate culture can be what we define as a deeply felt system of shared values and assumptions that explains how members of the organization think, feel, and act. What I want to add is that it's designed to have us think, feel, and act within that world. It's the creation of a universe in which we are to function. It's the very embeddedness of this corporate culture within Abercrombie & Fitch and its projection as a global brand that challenges the capacity of current anti-discrimination law to address the discrimination that it instantiates. Now, my comments are going to be somewhat legal. I mean, I'm sorry, I have to do it. But I want to situate it within the context of employment discrimination law because I think there are two particular dimensions of employment discrimination law that explain why this case is so tough. One, it has to do with sort of class action lawsuits against major corporations on the one hand, and the second, cases in which employers' grooming requirements are challenged as a form of discrimination. In both of these areas, you can see that employment discrimination law has been decidedly less than what one might hope for the reasons that I outlined below. In other words, what I'm saying is the case sits at the intersection of two gaping problems in employment discrimination law. The first factor to understand is that Abercrombie & Fitch is a major corporation that was challenged by the plaintiffs with employment discrimination, as distinct from something else like some other form of tort conduct. This is already an advantage for the defendant. Plaintiffs in such litigation are already pushing uphill, contrary to the popular perception that these cases are easy to bring and easy to win. Empirical studies tend to show that they are in fact the most difficult to win of any form of civil litigation. While it's true that it's very easy to file a complaint at the EEOC, there's about 100,000 filings annually, about 20,000 cases end up in federal court. Many employment law scholars have studied these outcomes to make a persuasive case that only 15% of the administrative filings before the EEOC actually result in any administrative relief. That's what John was referring to before. The fact that the EEOC even weighed in favor of the plaintiff in this case makes it extraordinary. That's usually not what happens. And secondly, that employment discrimination plaintiffs are the least likely to win when compared with plaintiffs filing personal injury or insurance suits. Furthermore, among employment discrimination lawsuits, race-based claims are particularly difficult to win. Recent studies that make this claim try to deal with the question of whether or not there are race-neutral reasons that explain the outcome, but the fact remains that racial discrimination under current law and procedure is often a losing cause, particularly, and this is most importantly, particularly when the cases are tried before a judge. It's virtually impossible to win the case. The low success rate, some scholars have argued, and I think persuasively so, is tied to the misperception fostered in the popular media that these cases are frivolous and too easy to bring. So we start with the sort of scale tilted against the suit to begin with. The fact that this litigation succeeded in beating these odds and actually achieved a $40 million settlement with payouts for past discrimination and all the things that Jahan described is no small achievement given the odds against it. The fact is, though, however, if we back up a moment and take a look at the A&F litigation in the context of other big lawsuits, like the Home Depot lawsuit, like the one against Texaco and Denny's, Michael Selmy, an employment discrimination scholar, has taken a look at a lot of these major suits and settlements and says that one of the interesting things about them is that even when you've got the multi-million-dollar settlements, the $100 million, the $150 million, I think it was $176 million in Texaco, the firm has not affected shareholder value. That is, one would think that with these kinds of payouts that it would be imposing some significant pain, but the corporate profit on these firms is actually so large that $176 million is not something that affects their overall shareholder value. It doesn't cut into what we might measure as corporate profit, notwithstanding the fact that the corporate management treats these cases as very serious threats. I mean, it's not to say that they treat them as minor, but the actual empirical effect on their corporate value is minimal. Nor have they resulted in substantial benefits, he argues, to the membership class, and I want to qualify this. If you ask the question, what would the plaintiff have won if they had filed an individual lawsuit, right? What would the damages have been won? They would have been significantly more than what the damages are actually paid out under these broader settlements. Now, of course, the trade-off is individual plaintiffs have a very difficult time making an individual case. So the advantage of the trade-off is that at least if you're in the class litigation, you have a better chance of attracting the kind of legal representation that's going to be able to successfully prosecute your case. But the point is it's about $10,000 per class member, and Selmy argues that's significantly lower than if you brought the lawsuit individually. The point that he's trying to bring home, and the point that I think I'm persuaded by, is that if we think about what the purpose of Title VII law was to begin with, it was to be more than just delivering a check to the plaintiffs. The idea was supposed to be some kind of use. In fact, employment discrimination law is considered to be the paradigm case of public law litigation. That is, it's supposed to be producing some kind of institutional reform along with monetary relief. And I think what we see when we look at these big settlement cases is that the monetary relief is what becomes our primary focus, in part because it's easier to measure, it's easier for us to figure out whether or not we've been successful, and the transformative part of it slips away. Now, I'm not saying that money isn't important. We all know that's not true. The point is that the cases, and Selmy argues, have become kind of another variation of a tort claim in which the public character of the litigation is being lost. And even where the conduct is clearly discriminatory, the resolution of the cases through settlements has provided little change in terms of the underlying corporate practices. In the Texaco case, for example, 1 year before the end of the settlement, not only had the company failed to meet its hiring guidelines, according to Selmy, much of the touted commitment of oversight to a diversity task force had not produced very much change either. The task force was supposed to be a part of internal company oversight, but it never criticized the company for failing to reach its goals, but it rather offered detailed public relations kinds of descriptions for why it failed to do so. Now, there are other more positive examples, like Denny's, which had actually somewhat of a better outcome, and certainly in Abercrombie and Fitch, we've actually seen real movement on the part of hiring practices. But it brings me to the second part where it's been more difficult, and that has to do with where employment doctrine sort of runs out. The question of how to deal with grooming cases has really been vexing in the context of employment discrimination law. Under current doctrine, employers can impose different grooming standards on the basis of sex, and that does not in and of itself establish a violation of Title VII. So while it's illegal to require women to wear a uniform and not put that same requirement on men, it is not, if the employer applies grooming standards to both sexes, the specific content of the rules and expectations can differ on the basis of gender. Thus, courts have held that men can be required to keep their hair short, women can be required to wear makeup, and all of this is considered to be consistent under employment discrimination law. That's not disparate treatment, but equal treatment, the court says, in this both men and women are being subjected to common standards. The early rationale for these cases was that the employer-mandated gender differences were acceptable because in adopting Title VII, the only thing that Congress was trying to do was to prohibit discrimination on the basis of immutable characteristics. Well, we kind of got away from that, but we're still stuck in the doctrine in this question of whether or not these requirements impose unequal burdens. And of course, at the end of the day, the court is hopelessly confused about how to evaluate that issue. On the one hand, the doctrine of Price Waterhouse, a famous case that challenged the failure to promote a woman to partner in Price Waterhouse because she was seen as being insufficiently feminine. That case seems to say to us one can't be punished for failing to meet a gender stereotype, and yet the grooming cases stand completely opposite to this line of authority that basically saying whatever an employer says, as long as he's saying it to both sexes, it's not a problem. The failure, I want to argue, to recognize sex discrimination in these grooming cases is compounded in the context of race and sexuality and what might be called appearance discrimination. Because the law has largely treated these grooming cases as de minimis injury or decisions that legitimately leave the prerogative to the employers, it's an easy move to say that the corporations have a right to require that their employees project a particular image or have a special appearance. Of course, to the extent that the image is racially or ethnically specific, that would seem to be a clear case of race discrimination, and that, of course, is why A&F settled. But the fact that A&F litigation challenged the way in which particular corporate aesthetics based on racial and sexual prototypes operated to affect hiring and promotion actually kept the case within a sort of recognizable anti-discrimination frame. The problem comes with the corporate aesthetic and branding, which is not so easily captured or challenged. The connection between the corporate image and the corporate practice is bound up with modern corporate marketing and the identity which prizes branding, or the sealing of product with image, or what I began with, the creation of a world in which we live, is the problem. And traditional anti-discrimination doctrine doesn't address this. I want to just take an opportunity to show you. John mentioned this is post-settlement Abercrombie and Fitch. This is the website. Okay, and I wanted to get to the photo gallery. All right. Just holler out if you see anybody brown or Asian. Just, raise your hand. They're selling clothes, right?
Right.
That's what I'm saying. They're not selling clothes. They're selling a world.
That's right.
They're selling a world.
You might be mixed.
Okay, what do you think? What do you
Half
think?
white and half European.
Okay, you get the picture. Now, where might we find, please, where might we find some colored people? There they are. What does it say? Diversity and inclusion are key to our organization's success. We are determined to have a diverse culture throughout our organization that benefits from the perspectives of each individual. Diversity is about who we are as individuals, what is seen and unseen. Let's stress unseen. Inclusion is about enabling those differences to equally contribute. Okay? Obviously, the smart lawyers for the plaintiffs are going to be challenging what is a fairly clear ghettoization of interpretation of the consent decree. If this is what putting racial and ethnic difference or diversity into the marketing means, this is how Abercrombie and Fitch has interpreted it. The problem is that there's not much in the way of doctrine to actually work with here. And that's because we're at a place where I want to basically argue that the law has run out. The limits of anti-discrimination law that are basically really laid open clearly by this case, and raises the question not only at the doctrinal level, what is the cause of action, or what is the connection that we can make to existing doctrine that would permit this to be challenged. The question is if the hiring practices are improved, is there still an injury? I want to argue that there is. And the problem is that we haven't yet captured the language either in law or in other places to describe it. So I want to end my conversation here and invite us into a discussion about where we might go from here. Thank you.
Thank you, Cheryl. So we now have time for some questions and comments from you all. And so, so we have until 3 o'clock. So if you could come to the mic, that would be most helpful, and raise your comments and questions to the panel. There are mics on either side, so start queuing up.
So this is a question, I guess, principally to Phillip Goff. So you called it the dehumanization IAT, and so I wanted to see if you thought that your findings were consistent with, I think this is Irene Blair's work on the Florida sentencing study. So in that study you find out that actually Afrocentric features do correlate with harshness of punishment, but it's only intra-race, only among all blacks you see something, among all whites you see something. I don't know, I think Jennifer Eberhardt has also done some work on it. And so part of it is just to reconcile those findings, but the second part I want you to step back a little bit more. As you're on the cutting edge of this kind of work, and think about how you find studies that are sometimes mutually reinforcing, sometimes a little bit different, sometimes finding different kinds of results. When you have that moment of, again, finding new knowledge, but having slightly different articulations, understandings, and conflicts, how is that addressed by policymakers, by lawyers, obviously, by the judiciary? What kinds of approaches do you, as a scientist, but also as a scientist who's concerned about public policy implications of the science, take when this kind of knowledge, but conflicted knowledge, starts appearing?
Okay. I'd like to thank you very much for the question. Love to have a chance to talk about Jennifer Eberhardt's work because it's also talking about my work. Jennifer and I are close collaborators. The work by Eberhardt and her colleagues and Irene Blair, I don't think that there's any conflict between that and the dehumanization work. Where we draw a distinction is one is about clear evidence of disparity. The previous IAT research is about prejudice, and this is about fundamentally seeing something other than human in the face and in the body of a human being. So it's sort of a broadening and building situation where we're not seeing a lot of conflict. In terms of where we see the overlap potential for policymakers, it would be lovely, it would be wonderful if policymakers came to us and said, we want to make changes as a result of this. That doesn't happen. That's never happened in my short career, nor in the long careers of Irene or Jennifer. What has happened is when we go out to policymakers and we explain, you might be liable, and we have proof. Want to hire us? Then we get some responses. So, for instance, the quotes I showed you from dispatches allowed me entree into the Denver Police Department. And I have to say, after it was clear what the lawsuits could be, the Denver Police Department was tremendously forthcoming and open, giving me tremendous access to do research with them. They're interested in changing policy from training to how they communicate with citizens and creating a sort of national model for doing this better. But I think this is where law and social science frequently interact, is in what are the good arguments for who's wrong and who's accountable, and what are they going to have to pay up before they have to engage in creating a better system. If that answers your question.
Just to build on that very quickly, if any of you are interested in that kind of work, it seems to me to be an area in which there's very little competition, there's very little supply of that expertise, and you can probably make that kind of case to a police department or a company to do risk management work to help them improve. And from what I saw of the companies that Abercrombie was enlisting to do this, we're not at the level of quality that we could be at. So dive in there because it's probably going to be hopefully it's going to be a big industry.
Hi, I wanted to do something that Devon ordinarily does, but since he's not doing it, I'll do it, which is to encourage at least two of the panel members to interact with each other and perhaps argue with each other. And in particular, I was wondering if Jahan could respond to some of the comments that Cheryl made, both in terms of the limitations of class actions, and then to have you both say a word about what sort of cause of action one could imagine, if not following on the heels of a consent order in which advertising was a focus of a remedy, if one were to imagine a cause of action starting from scratch with regard to advertising, what might that look like?
That is certainly a tough one. When we were talking about this on email before we came out here, David was talking about the advertising as hate speech, and we were talking about attacking the advertising directly, and it is an area. I agree with pretty much everything that's been said, and I am really excited to be part of this panel. But it strikes me as an area that's so problematic. Legally and practically, and there's so much to do. For each Abercrombie that I can find and hammer on, there are 10 other companies that are doing something almost as bad or just as bad. And so I've been wondering, is there a case against American Eagle, or is there a case against J. Crew? And we just don't know. And the reason that I highlighted Juan Carlos Gomez Montejano, who was the guy who started this in '99, and Anthony back there, it only takes one person who just says, this doesn't quite feel right, and then we investigate it. And for me, it all just turns on the statistics of, is value being transferred away from people of color or women or whatever in the employment context? So I know I'm totally dodging your question, but to me it just I'm kind of in the economic world, I guess, in terms of there are disparities, and you can see little ways in which companies are causing disparities, and the companies may not be evil in all situations. Abercrombie is, but they may just be accidental, and they may just be like the Denver Police Department, and they may just want a little bit of help. So I don't have a great answer for that, because it seems to me to be conceptually problematic and implementation-wise to be difficult to challenge. I mean, here we did build in this small sentence that I highlighted in the contract, the consent decree, and it's a contract, so we don't have to have a law to go to. We can just go to the contract and say you've broken our contract. But I'd be curious to hear what other people think.
I didn't really see that John and I had space for debate. I think he was. I'll be happy to try, but I thought that. Here we go. But I thought that what he was describing, or I thought that what I was describing was basically building on what he had described as the limitations of the law. And what I guess I would say is that it seems to me that one of the things that Abercrombie teaches is the very interconnectedness of the doctrinal problems across categories. And this is some of the work that Devon and others have done. But the point here is that one of the reasons that it's easy for Abercrombie to say this marketing is our prerogative and you don't get to mess with it, except with this little one sentence down here, is in part because of the problem around the grooming cases, that is around sex discrimination. So our ability to make a case about race discrimination is compromised by the weakness in the doctrine in sex discrimination. Similarly, our ability to make the doctrine better in sex discrimination is tied to our inability to make the doctrine better in sexual orientation, because after all, if we take seriously Price Waterhouse's command that you cannot punish an employee because they fail to meet a gender stereotype, what is that but the form of most sexual orientation discrimination? Failure to meet some gender stereotype. So I guess what I'm saying is the possibilities that seem to me here are, one, I mean, just as a practical matter, the existing space, it seems to me, within the doctrine is right there. That space around Price Waterhouse, that space around what does it mean when the court says you can't force somebody to meet your image of what you think a woman should be or what you think an X should be. I think that that's precisely the most, I guess I would say, fertile ground. The more you make it sound, however, frankly, I guess I would say, David, the frankly more you make it sound like it is hate speech, though the more uphill doctrinally you're going to get pushback. But that's not to say that I don't think that calling it what it is isn't important as well, because I think that's what I was trying to suggest. We're really at the nexus of sort of corporate culture and cultural norms, and the space between them is actually, or the line between them is actually very porous.
Can I say something in response to that? So, in terms of the legal strategy to win the economic settlement, right, that I don't feel like I have much to offer in terms of legal strategy. But I think one of the things that you said, Cheryl, which was so striking to me, and it picked up on precisely this doll experiment, right, is that experiment with Kenneth and Mamie Clark is something that actually brought not just monetary questions to Brown versus Board of Education, but here you have a Supreme Court constitutional decision that is about the psychic injury, right? That came up again and again in our various conversations. And so I'm fascinated in the ways in which the focus on the money settlement in these cases move us to what you say is another variation of a tort claim. And to me, that's about the privatization of race, right? And that is about, again, the harmonizing qualities of the market as the source of anti-racism. And what that does is it closes down what, queer scholar Lauren Ballant says is a public conversation in the public sphere around race, right? It's the incredibly shrinking public sphere. And so I do think that the ability to connect, right, both employment law, Title VII, to the questions of First and 14th Amendment as a kind of public issue is something that should be continually pressed.
I would agree. Sorry, no debate.
Unfortunately, this question is also for Professor Harris and Mr. Sagafi. It was related to Professor Harris, one thing that you concluded with, which was we don't yet have the language within the doctrine to deal with some of these cases at this intersection. And Mr. Sagafi, you had said, we on the ground who are actually doing this. Where do you see the need for, or how do you, as a practitioner, deal with a case where you might not have the doctrine yet? Do you go out on a limb and try and push something that there's no precedent for yet? Because I know there's probably a lot of pressure to bring a case that's actually going to win. So how do you, where does the newness come from in this conflict?
I think there's not necessarily a lot of newness up front. Like I said, what we do can be seen as fairly mundane. We find somebody who has a statistical discrepancy in who they're hiring and who they should be hiring, and we just beat the crap out of them if we can. And it may feel like the same battle over and over again, so it's not necessarily that sophisticated or sort of nuanced a theoretical thing. But I suppose in Abercrombie may be an example of something where you have the conventional structure to win the case as you need to, but it also has this interplay of new issues, and if you bring those new issues to the fore, then you can perhaps further the conversation almost incidentally of, what is stereotyping, what does this image really do? Now we can draw in the marketing because it is linked to the employment decision making, and so, perhaps that furthers things. But as a business matter, we do need to stay afloat, and we do need to take cases that are going to win. And so there's lots of righteous cases that we turn down because there's some obstacle, that we're just not going to be able to surmount. And if we hammer our head against a wall on a case that we can't do anything with, then we won't be there to fight the next three cases. So there is an element of conservatism there.
I guess I would say this is where I think the interdisciplinary work becomes really important. Much as I think we've begun to see the work of social psychologists around unconscious racism begin to have some migratory effects in the context of employment litigation. Not all salutary, by the way. I don't want to say that there's been sort of a direct translation of the best of the work into the cases. There's been a lot of pushback, actually. But the point is that you begin to at least see the court's willingness in trial to consider this as relevant evidence. And so I guess I would argue that one of the places might be at the point of an evidentiary question, like, okay, so what has the company actually done around this image question? Why is it important? What is, as David has suggested, the nature of the potential psychic injury, or as Cleo has talked about, what the psychic injury is? And why is it important? Why does it matter? What kind of environment does it set for working in a community if all of this is plastered around you, even if you have gotten the job? What are the messages that you're getting? So I'm saying I think there is some space. Admittedly, John is right. You know, you have to basically make some hardcore decisions here, or hard line decisions about how far you can push it. But I do think that that's precisely the value of some of the interdisciplinary work, because I think we basically need to undergo a re-education about what these cases are about, what they ought to be about, and what matters. Otherwise, we'll be stuck pushing up the hill that I described.
And if I could just quickly, I'm going to actually call on my colleague Jerry Kang to just speak to this just a little bit, because he's been thinking about the ways in which the importation of social psychology into law might actually follow a particular trajectory of pushback, incorporation, or not. So if you could just say something a little bit about how you see that psychology, because it very much relates to this question of newness and how that might shift some of the contemporary problems we've been discussing.
So it's always nice to be on the other side of the Socratic method. Now you know how it feels. So I certainly don't want to take up people's time, but so I've collaborated with psychologists, specifically co-authoring with them, and the whole goal has been to shorten the time frame that it takes to push new insights found in social cognitive neuroscience into the law, in part because the facts are incredibly powerful in making a particular case about how race works in our brains and why it is that the law should account for that. It's a movement towards being much more behaviorally realistic about, again, how racial discrimination works, and not accepting what are essentially caricatures about just truly evil people who want to, put crosses on fire in front of their lawn, and then the rest of us who are all okay. And so we do predict, and I'll just give you just the headlines. I mean, we predict a particular set of movements where the science will initially be denied, right? Then minimize interesting laboratory findings, but no predicted validity. Then politicize, right? The movement is, okay, you're finding some stuff, but hey, it's junk science. It's out there to politicize and justify wealth transfers. And there's been actually a huge pushback, increasingly in the academic literature now, suggesting in various ways, not that much different from either the climate debate or how smoking causes cancer debate was fought again. That's politicization, and then I think there'll be lots of justifications that come out eventually. There'll be justifications, well, it's ultimately rational because it was either selected for based on facts that we see on the ground, or evolution dictated it, evolutionary psychology justifications. And there will be other justifications that we simply can't change it whatsoever, and therefore we should just accept it. The descriptive will be slipped into the normative. Some final things will be that even if it's something that we can change, we shouldn't change it, either based on autonomy grounds, that we can't screw with people's brains. This is the hate speech First Amendment anxiety that happens whenever you want to intervene with the way that our brains fire. But of course, our brains are a function of the inputs that we take in, which include the media as the webs. I mean, these images are just stunning in the inputs that we get. And other equality grounds. And even though the background social norms reinforce a particular kind of inequality that probabilistically can be shown through these implicit associations and predictability tests, that doesn't mean the state should get involved with race-conscious intervention. In fact, that's no good. That would be race-conscious, and after Korematsu, we learned we can't do that. So that will be the chain of events that will unfold, and at each level you will have interventions, both with science and law. And I'm keenly interested in having the teams collaborate to make sure that it's done right, because failure will be catastrophic.
Okay, Cleo wanted to jump in, and then we'll have one more question after Cleo speaks.
I just want to mention that though there's laws and pre-existing norms around that result in people's oppression and marginalization and the perpetuation of whiteness, etc., what people can decide, even though they can't change these things overnight that we're talking about in terms of these ruts or these barriers, you can make some personal decisions around being involved in justice work as a way of life. You can also become conscientious around the high probability of internalizing those messages, that there's potential there, so you might not internalize them as much, which makes as a result of not knowing that that's occurring, you can be more abusive than you realize to people based on difference, or become part of the problem, or do what I call PC zombieism, And what I mean by that is people are doing a bunch of talking, but ain't nobody changing anything, because if they learn what to say, but they don't do anything about what to do. So you can find yourself in that spectrum and figure out where you want to be if you're interested in justice, because as we can see, justice work still needs to be done. And again, in closing, regardless of the barriers, you can do some things, but you got to make that decision.
Can I, sorry, just real quick on top of that? Sure. I did want to say, I wanted to say something along those lines, and you said it better than I would, so I'm not going to say it. But I think we've been exposed to a lot today, and you guys have learned stuff, and you will have a conversation, but the question is, just as Cleo said, what are you going to do about it? And so if you want to go and fight the fight and be a warrior for justice, you can do it, and it might be harder than going the easy route and being a corporate drone, but it's ultimately very rewarding, and we need you. So if you want to do one small thing, I'll give you the number for the monitor, and you can go to an Abercrombie and experience for yourself the images and see what it means to you, and feel free to call them, and if 20 of you guys call the monitor, it'll make a big impact. So the associate that works with him, her name is Erin Doyle. It's E-R-I-N. I'm not kidding. I want you to call. And her last name is D-O-Y-L-E, and they're in Palo Alto, 650-493-9300. And you just ask for Erin about the Abercrombie race discrimination case, and if you have any thoughts whatsoever about what Abercrombie means to us and what Abercrombie needs to do, tell them, and it will make a difference.
And our final question.
I wanted to ask the panel, given the history of oppression within this country towards people of color and gay people, why is it, to push you and question you about why is it we might want into this Abercrombie and Fitch look? Why do we want in, period? And I mean beyond the level of wanting to diversify and see images of people of color, which I think there can be an argument made about how useful that is on the ground. So for what? For why? Why do we want in? Why do we care? And then along with that, once those images get in, do we care about what they look like? So the images that we saw on the website, you know, they looked a certain kind of way. Do we care about that? And that's all I'll say.
So what way do they look?
Care and should we care?
Go ahead.
I just want you to be more explicit about the way that they look. Go on and say it, because see, we need to say it.
Do you mean white looking?
Yeah.
Okay.
Okay, she said it.
You know, that's a good point. We had people calling us saying there was something wrong with the way they were hiring, or they didn't do it right, or something like that. And people, it was amazing. I talked to 1,000 people who had experiences with Abercrombie, and the rarity with which people would say discrimination was really disappointing. And I just think it's something that we all struggle with, because it's it's the 21st century, and George Bush says it doesn't exist, so it doesn't exist, but it does.
Just to address your first question is, why do we care? Not to be overly self-referential, but to go back to the whole Negro ape metaphor thing, one of the most disturbing parts of the research is that unlike other implicit biases, so associating women with being bad at math, blacks with weapons, the elderly with being slow, people are aware of those stereotypes, right? If I ask you to raise your hand, have you ever heard of that before? Everybody's hands go up. Right? We asked our undergraduates, and then we asked our police officers, are you aware that the stereotype that African Americans or people of African descent have been represented as ape-like? And only 10% of them said yes. That means it's in there, but they don't know that it's in there. Right? So as opposed to these other implicit associations, and yet it's predictive of things like death. So when images can get up in you, right, through some kind of historical memory, stay up in you past the point where you're consciously aware that they ever existed, and then kill you, that's always a reason to care. Right? And now I'm not trying to be dismissive or trivializing of the question, because I think it matters. Do you want to be inside something, right, that hates you? Right? But when the thing that hates you has the power to kill you from the inside or from the outside, then I think it takes the choice away of whether or not you want to. And the question is, how will you?
I want to respond by saying I understand your question in that, and you can tell me if I'm wrong, if I'm paraphrasing incorrectly, that when whites are in charge of the people of color that get hired, it's usually based on their standard. And there's still oppression going on in terms of how people look. Not too black and not black enough, etc. And there's still a casualty, a psychic injury casualty that can occur in the midst of what looks like a multicultural, diverse phenomena. Because we're being taught and conditioned to think that it's wrong and racist to complain about that kind of racism. Because, I mean, even though only 10% of the people responded to what you said, probably only 10% remembered. Because some people don't know that they don't know that they don't know that they don't know. And that's why I mentioned earlier about the importance of critical thinking, being a critical thinker, and saying what's really going on, because I can't tell you how many conferences I've gone to where people will almost say that, look, seeing these light-skinned black people all the time, with me as an African-looking black person, is psychically injurious and also racist. So being fair does not mean hiring a bunch of light-skinned people. It means being actually diverse. And what's important about that, too, in terms of challenging that, is that a lot of black people, and others, I'm sure, but I only speak from the black experience, need to find out how to love ourselves. Need to recover from internalized white supremacy that could be perpetuated in blackface, light-skinned blackface. You hear what I'm saying? So we got to bring voice to that shadow conversation that's causing all this injury that's not being discussed as people think they're doing the right thing or claim they're doing the right thing and trying to make a multicultural or multicolored version of white supremacy.
Well, on that note, I want to thank the panelists. And I think part of what this ending point is helpful for us to contemplate is the extent to which the fight for equality within the workplace, it's not just a fight about intergroup differences, whether, for example, whites are being preferred over Asian Americans. The question invites us to think about whether or not intra-group distinctions are being made so that we can conceive of a moment in which Abercrombie and Fitch says, yes, we're going to hire, for example, blacks, but what type of blacks might be hired under that scenario? At any rate, thank you very much for your comments and the panelists. And Saul will now tell us precisely how we'll proceed for the rest of the afternoon.
Great, thank you. So we're running about 10 minutes behind schedule, but we do still want to give folks a 10-minute break because there will not be a break between the second panel and the keynote address. So we'll be back in this room in 10 minutes for the second panel.